All right, I figured this was worth going over. This is on my Bow and Cop Cam, our am say not pro se. California Guardian. He brings up some things that I think could use a little bit of clarification. So he's saying I'm assuming he means Bow, asked people to exercise their right to redress of grievances at a government agency or government official. Since when is redress of grievances harassment, and since when is it prohibited to anonymously redress the government? The first place we want to start here is the First Amendment. The First Amendment guarantees you the right to petition the government for a redress of grievances. It gives you the right to petition the government for a redress of grievances. Petition the government. So we have a couple questions here. Number one is calling someone petitioning them. And number two, are the law offices of Darla Peavy the government? Or even more broadly, is Darla Peavy the government? I submit to you that the answer to both is no. The relevant statute is the Texas Penal Code Section 42.07, harassment. It does not state anywhere in here that you cannot petition the government for redress of grievances. It does, however, say a person commits an offense if, with the intent to harass, annoy, alarm, abuse, torment, or embarrass another, the person causes the telephone of another to ring repeatedly or makes repeated telephone communications anonymously or in a manner reasonably likely to harass, annoy, alarm, abuse, torment, embarrass, or offend another. Now you're going to say, well, what if the government just thinks it's annoying? Then can all of a sudden they make it illegal? No, because you have to call with the intent. The government would have to prove that you were intending to harass, annoy, alarm, abuse, torment, or embarrass another. And then you would actually have to go about doing your action. You're calling someone in a manner reasonably likely to harass, annoy, alarm, abuse, torment, embarrass, or offend another. Now, if you doubt that a petition is written, this is the legal dictionary. A petition is a written application from a person or persons to some governing body or public official asking that some authority be exercised to grant relief, favors, or privileges, or it's a formal application made to a court in writing that requests action on a certain matter. Chisholm v. Georgia, they start talking about it. It's called a petition of right, where you can petition the king. This was just after the War of Independence, so we are still dealing heavily with laws that were imported from England, because remember, our laws did basically evolve out of English common law. And Marbury versus Madison sums up very nicely with the very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury. One of the first duties of government is to afford that protection. In Great Britain, the king himself is sued in the respectful form of a petition, and he never fails to comply with the judgment of his court. So petition has a meaning and government has a meaning. And the Texas Penal Code that was violated doesn't say anything about the petition of the government for redress of grievances. It says that you can't call someone with the intent to harass, annoy, alarm, abuse, whatever, in a manner that's likely to do that. So that's what it says. So I said calling the law offices of Darla Peavy is seeking redress of grievances. If I burn down her law offices, would that also be seeking redress of grievances? It becomes illegal when done in a fashion prohibited by law. And you may remember that conduct can be expression. Burning a draft card, if done for expressive purposes, may be speech. It can also be regulated, but it may be speech. And indeed, this Texas Penal Code is a conduct restriction, so it would fall under the same analysis. So California Guardian continues, burning down her offices is different than calling her office. Yes, it is different, but it's also the same because both are illegal if done with the intent to do it. If you accidentally burn down her law offices, then maybe it's not illegal. But if you intend to burn down her law office, that is arson. If you intend to call her with the intent to harass, annoy, alarm, embarrass, and you do it in a manner reasonably likely to harass, annoy, alarm, abuse, torment, embarrass, whatever, then it is illegal. So don't focus on how they're different. Focus on how they're the same. Because obviously they're different. One is arson, the other one is harassment. It is unlawful, or is it unlawful for members of the public to call a public official at their offices to voice to displeasure? It is unlawful if it violates that statute. And remember, the First Amendment doesn't guarantee you the right to address a public official anywhere, anytime, in any manner you please. It is the right to petition the government for redress of grievances. It doesn't mean you get to go to the personal space or the private business of that person who also happens to be a public official and do whatever you please. That is not how the law works. As to the language, I would... Oh, we missed something. As to the language, I would say it is a free speech issue. I wouldn't. I would say it is a conduct restriction. You don't get to be abusive. The courts have ruled that wood language is protected free speech. You can cuss. I believe he's talking about Cohen v. California. We've been over it before. And what the court actually held is that absent a more particularized and compelling reason for its actions, the state may not, consistently with the First and 14th Amendment, make the simple public display of this four-letter word, expletive, a criminal offense. So what it's saying is that if the state had a particularized and compelling reason, it could. Again, go back to the example of the kids in the park, the kiddie playground. You can't stand in the kiddie playground shouting cuss words. The police will probably find some ordinance that says you can't do it, and they'll remove you. Even though it is a public park open to the public, even though it is a traditional public forum, the government can and will regulate speech as long as it's in a public park. It would be as long as it's important or significant government interest, and it's narrowly, whatever regulation or rule is narrowly tailored to accomplish that significant interest. That's what they mean by more particularized and compelling. And if the government simply wants to ban cuss words altogether, then they would need a compelling government interest, and it would have to be narrowly tailored to achieve that compelling government interest. If they want to just ban swear words, and obviously they don't have a compelling government interest to do that, ergo, they haven't done it. But if you remember the Georgia video I did on breach of the peace statute, if you swear, if you use opprobrious language in front of a child or a young woman, then I think they cut it off at 14 and under, then that is a violation of that particular statute and has been held to be constitutional. So yes, they can rule against swear words. But the fun fact is that there is a case that is actually on point. Samuel Scott v. the State of Texas. Now, and as far as Bao calling and having, if Bao called himself, this would be like dead on point. But Bao had other people call for him, so there is some slight distinction. But essentially it is on point. So he called up, let's see, on or about the 12th of March 2006, Samuel Scott, with the intent to harass, annoy, alarm, abuse, torment, embarrass Yvette Scott, did make repeated telephone communications to the complainant in a manner reasonably likely to harass, annoy, alarm, abuse, torment, embarrass, and offend the complainant. To it, he called the complainant repeatedly by telephone while intoxicated late at night, leaving abusive and harassing voicemail messages. And this is the Texas Court of Criminal Appeals. This is essentially Texas's Supreme Court on the criminal side. Texas has a weird system where they have a Supreme Court that is the civil side, and then they have the Court of Criminal Appeals, which is the top Texas court for criminal cases. So turning to the meaning of section 42.07A4, that is what we are looking at. A4, that's what we're looking at in the Bow case. We find that, given the allegations in the charging instrument, the relevant portions of A4 reads as follows. A person commits an offense if, with intent to harass, annoy, alarm, abuse, torment, or embarrass another, he makes repeated telephone communications in a manner reasonably likely to harass, annoy, alarm, abuse, torment, embarrass, or offend another. We notice several things about that text. First, the text requires the actor have the specific intent to harass, annoy, abuse, torment, or embarrass the recipient of the telephone call. That is, the text requires that the actor have the intent to inflict harm on the victim in the form of one of the listed types of emotional distress. Second, the text requires that the actor make repeated telephone calls to the victim. One telephone call will not suffice. Third, the text requires that the actor make those telephone calls in a manner reasonably likely to harass, annoy, alarm, abuse, torment, embarrass, or offend the average person. Fourth, the text does not require that the actor use spoken words. Having examined the text of section 42.07A4, we conclude that it is not susceptible of application to communicative conduct that is protected by the First Amendment. In other words, the statutory subsection does not implicate the free speech guarantee of the First Amendment. The statutory subsection, by its plain text, is directed only at persons who, with the specific intent to inflict emotional distress, repeatedly use the telephone to invade another person's personal privacy and do so in a manner reasonably likely to inflict emotional distress. Given that plain text, we believe that the conduct to which the statutory subsection is susceptible of application will be, in the usual case, essentially non-communicative, even if the conduct includes spoken words. That is to say, in the usual case, persons whose conduct violates section 42.07A4 will not have an intent to engage in the legitimate communication of ideas, opinions, or information. They will only have the intent to inflict emotional distress for its own sake. To the extent that the statutory subsection is susceptible of application to communicative conduct, it is susceptible of such application only when that communicative conduct is not protected by the First Amendment because, under the circumstances presented, that communicative conduct invades the substantial privacy interests of another, the victim, in an essentially intolerable manner. We sustain the state's second ground for review. So I hope that clears it up. It is not a petition for the redress of grievances. It is not First Amendment protected activity. And just like you can violate statutes when you're filming, you can trespass even if you're holding a camera, you can be disruptive even when you're holding a camera. The same thing with words. You can trespass while speaking. You can be disruptive and disorderly while speaking. You can cause a breach of the peace with words. And you can commit the Texas crime of harassment with words or without. Anyway, thank you for watching. I hope this clears things up. I hope you found it informative and educational. And by the way, thank you, California Guardian. It might seem like I'm picking on you on this, but they were good questions, and I think we all could learn something from them. So thanks for watching. Have a great day.